Okay, Chapter 15, Part 4. We're continuing talking about bankruptcy. There were some other exemptions that we didn't cover in the last class. Public benefits are not subject to being taken by bankruptcy, such as Social Security and unemployment, and damage awards for a personal injury case cannot be taken up to a certain amount. There are also state exemptions that apply as well. So there are limitations in applying the homestead exemption that exempts the property, the real property of the debtor. If the property was acquired within 3.5 years of the filing, then you can only exempt up to $155,675. Okay, so the next thing is the process. A little bit about the process. So after the filing of the straight bankruptcy, there's a meeting of the creditors that occurs within 40 days. The meeting is run by the bankruptcy trustee. The judge is not there. The debtor has to be there. The creditors are allowed to be there if they want. Their option at being there is to participate by being able to ask questions of the debtor relating to the bankruptcy. Okay. The trustee is required to let the debtor know of any other options that they have other than bankruptcy, so as to avoid unnecessary bankruptcies. So the creditors, after the initial creditors meeting, if they want to get paid on their amount owed, they have to file a claim with the court. And in that claim, they list their name, address, and the amount owed to the creditor by the debtor. Then the property owned by the debtor is collected by the creditor, by the trustee, sold, and then the creditors are paid in accordance with rules established by the bankruptcy law, and a hierarchy of who gets paid first and who gets paid at lower levels. If there's any money left after the payment to all the creditors, it goes to the debtor. That would be highly unusual. After this, if it's completed properly, the debtor receives a discharge, and that means that nobody can try and collect from the debtor any previous debts owed. There are exceptions to this. For example, back taxes from the 2 years prior to the bankruptcy, federal taxes owed by the debtor, claims of any creditors who were not notified of the bankruptcy, any claims of property or funds received by the debtor under false pretenses or false representations, claims based upon fraud or misuse by the debtor, claims for amounts due on a retirement account loan. If you borrowed money from a retirement account, that is not exempt from, that is not discharged. Certain government fines and penalties, domestic support obligations, malicious conduct situations, and student loans. Student loans can be discharged under where there's an undue hardship. That's a very high level to prove. Any consumer debts of $650 or more for luxury goods are not discharged, and cash advances totaling $925 or more are exceptions to the discharge. Okay. Judgments against the debtor for driving under the influence are not dischargeable. Fees owed for homeowner associations are not dischargeable, and taxes due because the debtor did not file the right documents or provide documents to the IRS are also not dischargeable. The creditors can file objections to the discharge based upon the conduct of the debtor, where the debtor has concealed or destroyed property or financial records. This has to be done within 8 years. Also, the debtor is required to attend a consumer education course. The purpose of the course is to make sure that the debtor knows that they have perhaps other options besides a bankruptcy and how to prevent future bankruptcies. If they do not do that, then the discharge can be disallowed. If they're found guilty of certain felonies, then the discharge can be denied. When the discharge is denied, the property is still taken and distributed to the creditors. The debtor simply does not receive a discharge and still owes any of those creditors that were not paid through the proceeds of what was taken. Okay. So, reaffirmation of the debt. Here, the debtor agrees to pay a creditor, and they enter into a written agreement. This is within the bankruptcy, but it is sort of like outside of it in a way also. So this typically happens with automobiles. So the debtor needs to keep their automobile to have transportation. So they enter into an agreement with the bank whereby they agree that if they keep the car, they're going to pay the debt as it becomes due to the bank. So there's no discharge of that obligation. Okay, so we're going to stop here and pick back up in part 5 with the rest of bankruptcy. Again, the magic word for this chapter is bankrupt.